Can a state tax a sale that was completed in another state simply because a pipeline passes through its territory? The Supreme Court of India has answered that question with unmistakable clarity, and the answer is no. The judgment I am discussing today is State of Uttar Pradesh versus Reliance Industries Limited, decided by a division bench of the Supreme Court, comprising Justice J.K. Maheshwari and Justice Atul S. Chandrakar on the 15th of May 2026. At the center of this dispute is natural gas extracted from the famous KGD6 block in the Krishna Godavari Basin, 2026, and whether the state of Uttar Pradesh had any right to levy VAT on its sale. Here are the facts. Reliance Industries Limited extracted natural gas from its KGD6 deep water block off the coast of Andhra Pradesh. Under a production sharing contract with the Government of India, RIL sold this gas to various buyers, including companies in Uttar Pradesh, through a gas sales and purchase agreement, or GSPA. The delivery point under the GSPA was Gadamoga in Andhra Pradesh, where RIL handed over the gas. Measurement was done, and both title and risk passed to the buyer. From Gadamoga, the gas traveled through RGTIL's pipeline to Hazira in Gujarat, and then through GAIL's pipeline to Araya in Uttar Pradesh, over 1,000 kilometers away. The Uttar Pradesh tax authorities said the gas was commingled in a common pipeline. We cannot identify whose gas is whose until it reaches our state, so the sale happens here, and we will levy VAT. They passed an assessment order demanding VAT at 21%. 3 legal questions had to be answered. First, is this an interstate sale under Section 3 of the Central Sales Tax Act, which would be exclusively taxable by the Union, or an intrastate sale subject to UP's VAT? Second, does commingling of gas in a common carrier pipeline convert an already concluded sale into an unascertained goods transaction localized in UP? And third, does the 2016 amendment to Section 3 of the CST Act, which expressly covers common carrier pipeline gas transactions, apply only from 2016, or does it clarify what the law always was? The Supreme Court answered all 3 questions decisively in favor of RIL. The court held that once a transaction satisfies the requirements of Section 3 of the CST Act, meaning a contract of sale that occasions interstate movement of goods, Section 4 of the Act simply has no application. The Constitution bench in Tata Iron and Steel vs. R. Sarkar had already said, if a sale happens to come under both definitions, it would have to be taken as a sale in the course of interstate trade. For Section 4 has been made subject to Section 3. On commingling, the court said the gas was already metered and delivered at Gadamoga. Title had already passed. The subsequent mixing in the pipeline was a statutory compulsion under PNGRB regulations, not a commercial choice. The commingling could not reopen a sale that was already complete. On the 2016 amendment, the court held it was clarificatory, formalizing what was always the legal position, and therefore operated retrospectively. Crucially, the court also pointed out that UP had itself issued Form C declarations to the buyers, acknowledging the interstate character of these very transactions. Having done that, UP could not turn around and claim the sales were local. The takeaway for practitioners and businesses is this. The constitutional boundary between interstate and intrastate sales is not a matter of contractual drafting alone. It flows from the Constitution itself. States cannot use commingling, fungibility arguments, or even the public trust doctrine to create taxing jurisdiction where the Constitution has given them none. Gas infrastructure operators and industrial consumers in UP and other receiving states can take significant comfort from this ruling. For the complete legal analysis of this judgment, read PV Legal's daily newsletter. I am your new host. Stay legally informed.